Today is day 9 February 2024. We are having a lot of problems at the communication by, you know, interference made, and some acts has no excuse because indeed hadn't excused down here. So there are no rational argument to sustain the illicit activity inside an institution on architecture of power. The American Constitution has an amendment, I would say 14th amendment, which is basically saying the equal protection and other rights. I'm not a professional of law. I don't have enough knowledge about the US history or the Constitution, but I can get by my humble sense as administration trying to do the optimization from my self-defense and as equal condition based on our humanity. I think that in my mind I can help some way if I'm having and kind of got forced to struggle something that goes around beyond the sense of difference. Beyond the sense of difference, it implies that she is strong enough to hurt anyone in any area, and by this there are no jurisdiction applied into it, or we probably would have the limit some way or in some moment, and this of course that she would cut my speech, I would say, about this argument at the American history, which is on the first section saying the rights. That the most relevant thing here, I think, that is have the due process of law, which is kind of the regular limits as users of power. And we will have that the first clause that we have here, and I'm using the Congress of the United States as website, is saying that we have the citizenship, the privileges and immunities. We have the specific types of immunities as special citizens that are the House of Representatives and others. And we have also the very early days as the doctrine to incorporate the Bill of Rights, which is, I think, that is the very essential condition to form the civil rights in the United States. And then we have finally the overview as procedural due process. It means that is a process to use the power by procedural limits. And indeed, it's the main point here at the current case, which you have sustained that the interference made can be made by an excuse, and also has the argument that the amendment, I would say, has that no state should encourage the or enforce privileges or immunities of the United States, and has some conditions that affect the person's life, liberty or property without due process of law. The first thing, it implies that it's acceptable the United States have strike back some rights like the person life, liberty or property, since not doing this without the due process of law. The first thing, and by this as inference, it's told that the due process of law it's not only the exclusive and unique way to strike back those rights, and then we will move forward. The criminal cases is essential relevant have the procedural due process of law for sure. And here is the point. If your citizen as national, and I'm talking as European Service Portugal because I request and required a dozen times to have no ties with the criminal system that is ruled by Brazil with peers, and Brazil is the major offender. We will have the first condition is impartial judge and jury, and the identification in a pre-trial process. And then we have the situation that we close the case in tears and change our history forever because we're using philosophy. So, they're Italian, but sourced on Portugal by ties, blood ties. It's like this. The identification in a pre-trial process. It's kind of the simulation before you launch the product inside your company is the same thing. And the guilt beyond a reasonable doubt. It means that it's the situation when the guilt is kind of overcoming the elements as indictment to set the doubt. But since you do the fake records, we suggest that to use the new ways offered at the blog. And here is the most relevant thing I think that it is in this case and forever in United States history, which is the impartial judge and jury, which implies the judge as a special citizen as condition choice are designated by a representative as chair number 1, and the jury as the great jury as a temporary, generally special citizens as condition to be at this position. But the object is not a common crime or criminal that you can have this word yet because the trial didn't finish it. And also it's an ex-president, for instance, which implies the regular process as electoral process. And also all things are kind of oversight, I would say, by the Congress. And the last section at this amendment, I would say, it's kind of saying that the Congress will do the regulation of cases. But let me make you a single question, and then we can finish our conversation. Is the object considering the preparation as trial, which has a name here? It's the pre-trial process, has elements of crimes. Is this confirmed? First question. Second question. Do we have not partial judge and jury formed by citizens of the United States to do the judgment as a condition, which implies the straight use and limits of electoral process in United States? because the judge probably or the citizen will be a voter also. So we have the, if we continue this way, the suspicions of the judicial power, right? And we do not consider something rational, push things this way. Am I telling absurd? American people, it's your constitution. And the issue, in my opinion, is closed. Kind of, you have limits to do the cognition. I mean, you have no limits to do the cognition, but you have limits to recognize the object that you previously had the cognition, because there are no judge or jury, which implies the substance and the design as judicial power in United States without partiality to do the judgment about the electoral issue, even if it's not immediately related as the criminal object or elements at the indictment or the petition as conviction of the prosecution, right? But it's not my area. I'm giving you a tip, which is quite clear here. The procedural due process has a pre-trial, seems that the great jury, and a post-trial, then you have the decision in criminal cases. But the criminal cases having as object holed the behavior of an ex-president with a possible or the possibility as indictment or conviction as criminal, this can't be made by the great jury or as a special citizen temporary, or the judicial power as judge special citizen, because they are also voters. They have in some way any kind of interest at this specific object, which is the behavior of one special citizen that she has this qualification forever as part of the constitution, the history of the United States, because it was a president that had the entire period. And by circumstance seems that even on jail, this special citizen can achieve the chair number one more time, which will put the things in a situation even more uncomfortable. And to prevent this, you as United States, for instance, considering this amendment, has the situation as naturalized citizen, for instance, without interest to do the case, right? It's a condition also special, and by this I require the past to consider the special condition to present the argument as financial arguments and the reasons to sustain the US defensive system in the way I'm doing right now, because it's the advice here and finish. The object as audit, governance, risk and compliance, the administration of risk and management of a system, considering the USA and Europe, with drivers and effort, we offer redundant interference. At this case, there are no not partial judge or great jury to do the judgment of an ex-president with the object as behavior related with the electoral process. Have a great night. Did you provoke it or evoke me?